Present estates. There are 4 kinds of present estates: fee simple absolute, fee tail, defeasible fees, life estate. There are 3 essential questions to ask about each estate. What language creates the estate? How does the estate transfer? Does the estate involve a future interest? With respect to the second question, how does the estate transfer? We're asking, is it divisible, meaning can the estate pass by will? We're also asking, is it descendable, meaning will the estate pass by statutes of intestacy if its holder dies without a will? And we're also asking, is it alienable, meaning is the estate transferable inter vivos, where inter vivos means during the holder's lifetime. Fee simple absolute. A fee simple absolute is an interest in land that is absolute, unconditional, and lasts forever. You should note, this is the best level of ownership that someone could have. The language that creates it is 2A or 2A and his heirs. How does it transfer? Well, it's divisible, descendable, and alienable. Any future interest? None. For example, grantor conveys land to A and his heirs. If A is alive, do A's heirs have a future interest? No. A's heirs have nothing. The important rule to remember is that a living person has no heirs. Living people may have prospective heirs, but they are not considered in the analysis of a fee simple absolute. Thus, in analyzing a fee simple absolute, the language 2A and his heirs is the same as 2A. Fee tail. A fee tail is an interest in land that is only transferable to blood-related descendants. The language that creates a fee tail is 2A and the heirs of his body. Note, the fee tail is obsolete because it has been abolished in almost all states. Thus, it is almost never tested on the bar. Also note, an attempt to create a fee tail results in a fee simple absolute. The intent on the fee tail was to ensure control within blood-related descendants. Any future interests? If the future interest was in the grantor, it was called a reversion. If the future interest was in a third party, it was called a remainder. Defeasible fees. There are 3 types of defeasible fees: fee simple determinable, fee simple subject to conditions subsequent, and fee simple subject to executory limitation. Fee simple determinable. A fee simple determinable is an interest in land where if a certain event happens, the interest will automatically end and be transferred back to the grantor. The language that creates a fee simple determinable is 2A for so long as, 2A as long as, 2A during, 2A until. As you can see, the grantor must use durational language. How does a fee simple determinable transfer? A fee simple determinable is divisible, descendable, and alienable, but always subject to the condition. Here are some examples of a fee simple determinable. The King of Russia conveys land to the princess as long as the land is not used for singing. The princess has a fee simple determinable, and the King of Russia has a possibility of reverter. Now suppose that the princess is madly in love and dating Frank Sinatra. She conveys the land to him. Frank Sinatra wants to create a studio for singing on the land. Can Frank Sinatra do that? No. Frank Sinatra can only get what the princess had to give. So the king's restriction will always apply no matter how many transfers occur. And if the land is ever used for singing, then the land would revert back to the king. Are there any future interests? The future interest is in the grantor, and is called the possibility of reverter. Note, the possibility of reverter only accompanies the fee simple determinable, and no other estate. To help remember this, remember the acronym FSDPOR as Frank Sinatra dated the Princess of Russia. Fee simple subject to condition subsequent. A fee simple subject to condition subsequent is an interest in land that will end if both a certain event happens and the grantor chooses to take back the land. Note, it is similar to the fee simple determinable. The difference is that the fee simple subject to condition subsequent requires an additional step before the estate is terminated. In other words, a fee simple determinable will automatically end if the grantee does not fulfill the condition. but a fee simple subject to condition subsequent will only end if both the grantee does not fulfill the condition and the grantor chooses to take back the land. The language that creates a fee simple subject to condition subsequent is 2a, but if some event occurs, grantor reserves the right to re-enter. There are two specific requirements. Grantor must use durational language, and grantor must state the right of entry. How does it transfer? It is divisible, descendable, and alienable, but always subject to the condition and if the grantor decides to take back the land. For example, A conveys to B, but if steroids are ever consumed on the premises, grantor retains the right of entry. B has a fee simple subject to condition subsequent, and A has a right of entry. Are there any future interests? The future interest is in the grantor, and is called a right of entry. Fee simple subject to executory limitation. A fee simple subject to executory limitation is an interest in land where if a certain event happens, the interest will automatically end and be transferred to someone else. Note, it is similar to the fee simple determinable. The difference lies in who the interest in land is transferred to when a condition is violated. Instead of reverting back to the grantor, with a fee simple subject to executory limitation, the interest is transferred to someone else. The language that creates a fee simple subject to executory limitation is 2a, but if some event occurs, then to B. The grantor must use durational language, and the grantor must state to whom the interest will transfer. For example, A conveys to B, but if B ever leaves the premises, then to C. B has a fee simple subject to executory limitation, and C has a shifting executory interest. How does a fee simple subject to executory limitation transfer? It is divisible, descendable, and alienable, but always subject to the condition. Are there any future interests? The future interest is called a shifting executory interest, and it is held by whomever the grantor designates. Note the important language of defeasible fees. Defeasible fees must have clear durational language. Thus, if the language only rises to the level of intent, it cannot be a defeasible fee. Here are some examples to show that language of intent does not create a defeasible fee. 2a with the hope that there will always be a garden. 2a for the purpose of building a racetrack. 2a with the intention that alcohol will not be consumed on the premises. 2a with the expectation that the land will be used for a soccer field. The rule against restraints on alienation also limit the language of a defeasible fee. Language that completely restricts the ability to sell is void. For example, A conveys to B, but if he ever tries to sell, then to C. This is an absolute restraint on alienation, and is considered void. Instead, B has a fee simple absolute. Life estate. A life estate is an interest in land that lasts only as long as the life of the recipient. Note, a life estate can also be measured by the life of a different person instead of the recipient. This is known as the life estate per atra v, where per atra v means for the life of another. The language that creates a life estate is 2a for life, and the language that creates a life estate per atra v is 2a for the life of B. Note, the language must only include terms that mean lifetime. So, if there is language that includes a certain number of years, then there is no life estate. Here are examples of when a life estate fails to exist because a certain amount of years is mentioned. 2a for 40 years if she lives that long. This is not a life estate. 2a for life, but not for more than 50 years. This is not a life estate. Again, these cannot be a life estate because a certain number of years is mentioned. Instead, they are examples of a term of years. Here is an example of a life estate. A conveys land to B for life. B has a life estate, and A has a reversion. Even though there is no mention that the estate reverts back to A after B's life, it is implied. Thus, both statements, to B for life then back to A, and to B for life are treated the same, with A having a reversion. Here are two examples of a life estate per atra v. A conveys to B for the life of X. B has a life estate per atra v, and A has a reversion. A conveys to B for life. B then sells the land to C. C has a life estate per atra v, and A has a reversion because at the end of B's life, the estate transfers from C back to A, the grantor. How does a life estate transfer? It is divisible, descendable, and alienable, as long as the measuring life is still alive. Are there any future interests? If the future interest is in the grantor, it is called a reversion. If the future interest is in someone other than the grantor, it is called a remainder. Note: it is important to learn and remember that life estates are connected to the concept of waste. Those who hold a life estate called life tenants are entitled to all ordinary uses from the land. However, life tenants must not commit waste. This means that since the life tenant's ownership is temporary, he must not do anything to harm the future landowners. There are 3 types of waste: voluntary waste, permissive waste, and ameliorative waste. Voluntary waste is overt conduct that causes a decrease in value. Note: specific to voluntary waste is the discussion of natural resource depletion. A life tenant must not deplete natural resources, unless it is for an orgy. The orgy exceptions are open mine doctrine, repairs, grant, exploitation. The open mine doctrine is where the life tenant is utilizing a mine which was already open before the life tenant's ownership. Repairs is where the life tenant is consuming natural resources for repairs. Grant is where the life tenant has a written grant of permission. Exploitation is where the normal use of the land is to exploit the natural resources. Permissive waste is, in other words, neglect. It occurs when the land falls into disrepair. Thus, the life tenant must maintain the estate in reasonably good repair. The life tenant must pay taxes associated with the land, including taxes on income made from using the land. If no income is made, then the life tenant must pay tax on the fair rental value of the land, and the life tenant must pay interest if the land has a mortgage. Ameliorative waste. This means that the life tenant must not alter the property in a way that increases the property's value, unless it is possible to know who the future landowners will be, and the future landowners give their consent. This rule exists to honor future landowners that may not want improvements.